So Joseph Smoot from Housing Rights Committee. Actually, it's great to have Jennifer Fever here from the Tenants Union. So all I know is kind of the impact on the ground that we're seeing as a result of demolitions and kind of abusive demolitions today, and what we're kind of forecasting into the kind of future abuses that are being set up by owners for trying to get rid of tenants. So the first thing that I'll highlight is demolitions of accessory dwelling units, so in-law units. So one of the things that we see a lot is if somebody's not paying market rent in an accessory dwelling unit, and that unit is not able to be brought up to code, that's one scenario, is that the owner will basically apply for a demolition permit, remove the kitchen, remove the tenant, because the unit can't be brought up to code, and then what they'll do is they'll put the kitchen back after the inspectors have gone, and then they'll move a new tenant in. So that's one thing that we're seeing that's obviously problematic. So the accessory dwelling unit stays, the kitchen just gets removed and it gets put back. So that's one problem. Another problem that we're seeing is demolitions of pre-1979 structures. So 1979 is the cutoff in San Francisco for rent control. And that's now restricted by the Costa-Hawkins Rental Housing Act, which is state law. So anyway, obviously when somebody demolishes a pre-1979 structure and then they build a new structure, that new structure is not restricted by rent control any longer. And there is a law now, or there's a proposed bill at the state level right now to repeal the Costa-Hawkins Rental Housing Act. It seems like it would kind of go along with this proposal to update the demolition codes locally to make sure that there is a repeal of Costa-Hawkins Rental Housing Act, to make sure that we can extend rent control to all rental buildings throughout San Francisco, so that we don't have this problem of when a pre-1979 structure is demolished and then a new one's built, that the new one is no longer subject to rent control. So second issue. Third issue, we are seeing, even with this change not implemented yet, as Elizabeth said, it's been in process for a year now, hasn't been implemented. We're seeing a ton of planning applications right now being filed by property owners throughout at least the west side, which is where I'm working right now, in the Richmond district, throughout the Sunset, where properties are zoned RH2, RH3, sometimes RM, and there's a single family home. In the single family home, these permit applications that we're seeing are to expand the building envelope of the existing family home in order to add a second or third dwelling unit that are legal. So these are not accessory dwelling units, these are new legal units. What we're concerned about is that right now the rent board doesn't, as Elizabeth said, the rent board doesn't know right now, because they don't have clear direction on how to look at the new structure. When we call the rent board to find out, well, are we adding rent-controlled housing stock? It seems like this is a great opportunity, right? But we wanted to make sure that the new units would be covered under rent control, because the original structure is built before 1979. The rent board is actually looking at these on what they call a case-by-case basis, which kind of scares the crap out of us. And one of the things that's complicated is that if you get a new certificate of occupancy, once the new units are put in place, a new certificate of occupancy can trigger basically a resetting of the clock. Now, even though the original structure, the original foundation, and most of the structure that remains was built before 1979, there's a new certificate of occupancy for the newly expanded building with the new units. So what we're hoping is that we can get clarification that the new building, once it's built, will actually be subject to rent control. We've been through this discussion with buildings that have been either demolished or damaged through fires. And there's been a whole working group with the Department with planning and with fire and with DBI to look at fire damaged buildings we're hoping that and those will still be subject to rent control once they're refurbished or once they're rebuilt. We're hoping that we can get something similar to this. There was actually, Jennifer and I were just in a meeting earlier today, actually, where there's a report about a number of buildings in the Tenderloin that haven't even been significantly rehabbed, where a major property owner of like probably thousands of units in the city has actually claimed that that the buildings that have not been demolished, have not been torn down, and by most kind of subjective measures at least, probably would not have even been considered to be substantially rehabbed. They are claiming that they have done enough work that takes them off of the rent control rolls, and so are raising rents in those buildings to try to get tenants out. This is happening in the Tenderloin right now. Yeah, so anyway, that's pretty much it. I mean, we would also encourage that any kind of demolition or remodel triggers some kind of a hearing. So.